See Kim Kardashian, DNA evidence claims murder, recanted witnesses, and a non-unanimous jury. These are the fragments of one of the most contentious criminal cases in the history of hip-hop, and we will examine each and every one of them. People have been choosing sides in the Corey Miller case for more than 20 years. Let's discuss whether new evidence has truly shown his innocence and whether the murder has now been made public. We must return to the beginning in order to comprehend where we are now. The date of Corey Miller's birth is March 9, 1971, and he would develop into one of the most well-known figures in Southern rap. He was raised in the Colopy Projects in the 3rd Ward of New Orleans with his sister Jermaine, brother Silk the Shocker, Master P, and Kevin Miller. He was born in uptown New Orleans, Louisiana, in a city already recognized for its high crime rates. The Colopy Projects in the 1970s and 1980s were among the hardest neighborhoods. He grew up in New Orleans' extremely dangerous 3rd Ward residential projects. The Miller family was not confined to those enterprises indefinitely, though. Music Master, his eldest brother, was a standout basketball player in high school and was awarded a basketball scholarship to attend the University of Houston. But once his grandfather passed away, Percy left school months into his first year. As part of the malpractice settlement, Percy inherited $10,000 and opened No Limit Records, a record store. In the end, that record store would grow to become one of the most important record companies in hip-hop history. And one of the performers at the heart of that movement was Corey Miller, who now performs under the stage moniker C Murder. He first became well-known in the middle of the 1990s as a member of his brother Master P's label No Limit Records, mainly as a member of the label supergroup TOU. When No Limit Records took off, Master, his brother C Murder, and Silk the Shocker formed the trio. They were all over the place. Fans couldn't get enough of the new albums that seemed to be released every month. Corey Miller joined the U.S. Army following his high school graduation. During the Gulf War, he was sent to the Persian Gulf as a combat medic. Many individuals are unaware of this aspect of C Murder. He was a soldier before he even entered a recording booth. After serving his country, he entered the music industry alongside his brother. Miller's debut album, Life or Death, reached number 3 on the Billboard 200 and was later certified platinum in 1998. He became well-known not only as Master's little brother but also as a solo musician after the record. Bossellini, which he released in 1999, was certified gold and peaked at number 2 on the Billboard 200. His album Trapped in Crime reached number 9 on the Billboard 200 in 2000. In 3 years, 3 albums have all charted in the top 10. C Murder's career was at its pinnacle. C Murder has put out 9 albums on 6 different labels. The record labels associated with C Murder include Asylum Records, RBC Records, KO Records, TAU Records, Vino, and No Limit Records. However, everything changed on January 12, 2002. Miller was found guilty of second-degree murder in September 2003. Regarding the beating and shooting death of 16-year-old Steve Thomas, a fan, on January 12, 2002, at the Platinum Club, a closed nightclub in Harvey, Louisiana. Corey Miller was directly blamed for the death of a 16-year-old SE murder enthusiast. Thomas was shot and beaten to death in Louisiana's Platinum nightclub on the evening of January 12, 2002. The nightclub was packed, according to several accounts. Murder was either performing that evening or at the very least in attendance as a celebrity. There was a problem. A gun fired off as a fight broke out. Steve Thomas was struck and died. Miller was charged with Thomas's murder shortly after being detained early on January 18 for inciting a disturbance at the House of Blues in New Orleans. On February 28, 2002, he was charged. This is the foundation of the prosecution's case. The musician was found guilty of second-degree murder after bouncer Donnell Jordan and unrelated Kenneth Jordan both claimed to have witnessed C Murder Thomas. 2 unrelated eyewitnesses called Jordan claimed to have seen C Murder pull the gun. That served as the case's cornerstone. This is the point at which things become difficult. As stated by lawyer Philip C. There's no tangible proof. Hamilton. Nothing about their finding a gun has come to your attention. Nothing regarding DNA was mentioned. No security footage was present. No confession was made. It all came down to the witness accounts of these two main people who claimed to have witnessed the incident. There were just two witnesses pointing to a murder. No gun, DNA, video, or confession was found. The trial itself went through several stages and revealed systemic flaws that are still up for debate. In April 2004, Judge Martha Kahn authorized a fresh trial on the grounds that three of the prosecution's witnesses had their criminal backgrounds illegally concealed. Take a moment to consider that. Because the prosecution concealed information regarding its own witnesses, the first conviction was overturned. This is noteworthy because it indicates that the jurors in the initial trial were not fully informed about the witnesses who were testifying against C. Murder. They were unaware of the criminal histories of those the state depended on. Miller was put under house arrest and freed on a $500,000 bond on March 20, 2006. The same homicide was still being committed during this time. While on home arrest, Sis let Miller advertise his upcoming CD and his book, Death Around the Corner, but she decided that a gag order related to the case would stay in place. However, there was another instance that damaged the reputation of Murder prior to the retrial on the murder charges. Miller entered a no-contest plea to 2 counts of attempted second-degree murder on May 27, 2009. These accusations are related to an event that occurred in Baton Rouge in 2001 when Miller fired a single shot from a semi-automatic pistol at the nightclub's owner and bouncer, who refused to let Miller into the establishment with the weapon. Miller received a 10-year sentence with credit for time served. A different conviction, a different occurrence. Even if a jury is instructed not to take this type of prior record into account, it makes it more difficult for them to give a defendant the benefit of the doubt. The second murder trial followed. The murder trial started on August 5, 2009. Before the tragedy, the victim's father mentioned that his son enjoyed C. Murders. Additionally, a bouncer who claimed to have seen a shooting testified against Miller. He said he was afraid of the consequences of his testimony. Additionally, prosecutors accused S. Murder's colleagues of tampering with witnesses. The trial proceeded swiftly before the jury was called. The jury reported a deadlock on August 10, 2009, but Judge Hans Lee gave them instructions to try to break the impasse. The jury returned 3 hours later to declare a guilty verdict of 10-2. Given the earlier announcement of a deadlock and the swift reversal, the judge surmised that one of the jurors had chosen to switch under duress in order to end the trial and gave the jury instructions to return and continue deliberating the matter. Miller was found guilty of second-degree murder when they returned with the same 10-2 decision. At this point, the case begins to deviate from the majority of murder cases in the United States. That 102 verdict would have been a hung jury in 48 states as well as federal court. However, non-unanimous jury decisions were permitted in Louisiana at the time. It didn't matter that 2 jurors found the defendant not guilty. Mary Jacob, one of the jurors, claimed that she and another juror, a 20-year-old Xavier University of Louisiana student, were verbally attacked by other jurors for their choice to resign. Jacob claims that a juror became physically unwell as a result of the extreme pressure. This is a sworn testimony from a juror who was present in the deliberation room stating that she changed her vote because she could no longer stand the abuse, not because of the evidence. This was brought up as a crucial point by Miller's lawyer, who said that one jury voted guilty not because of the evidence, but rather because she wanted to put an end to the proceedings in order to protect another juror who had refused to convict Miller but had been pressured by other jurors to change her mind. The U.S. Supreme Court ruled in Ramos v. Louisiana USI that the U.S. Constitution's Sixth Amendment requires that guilty verdicts in criminal trials be unanimous. The ruling also incorporated the Sixth Amendment requirement for unanimous jury criminal convictions against the states, overturning the court's previous decision from the 1972 cases Apodaca v. Oregon and Johnson v. Louisiana. Let's take a look at why that 10-2 jury verdict matters beyond a single case. On music, only Oregon and Louisiana permitted non-unanimous jury convictions at the time of the ruling. The U.S. Supreme Court stated what proponents of C. Murder have been advocating for years in 2020. Jury decisions that are not unanimous are unconstitutional. The jury convicted Corey 102, and he would be sentenced to life in prison. If his trial had been today, the jury would have had to be unanimous for him to be convicted. But there was a catch, Kim Kardashian tweeted. In Edwards v. Vino, The Supreme Court subsequently decided that the Ramos ruling does not apply retrospectively to those who had previously used up all of their remedies. C. Moda had used up all of his direct appeals. Miller's final appeal of his conviction, Miller versus Louisiana, was denied by the Supreme Court on February 19, 2013, so even though the system that found him guilty was ruled to be unconstitutional, that decision could not assist him. If the non-unanimous jury issue was one side of C. Moda's battle, the witness recantations were the other. Lawyers, celebrities, and the general public have all expressed indignation about what transpired with these witnesses. Miller's case was highlighted on Investigation Discovery in June 2018. On this episode, Kenneth Jordan recanted and talked about his false testimony. He claimed that detectives had forced him to testify against Miller, or else he would have been sentenced to 10 years in prison for unrelated criminal charges. This is a witness going on national television and claiming that he had been forced to lie under oath by law enforcement. In 2018, Kenneth Jordan, one of the two key witnesses who identified rapper Corey C. Murder Miller as the lone gunman in a Harvey nightclub killing in 2002, recanted his testimony, claiming in a sworn statement that he was coerced by Jefferson Parish Sheriff's Office detectives to lie under oath or risk a 10-year sentence on unrelated criminal charges. Music. At the time, Jordan stated, "I know the person that I saw shoot the gun was not Corey Miller, and it was not just Kenneth Jordan." In 2018, Donnell Jordan, the second important witness, also stated that he was under pressure to lie under oath. The witnesses are unrelated, despite having the same last name. Donnell also signed a paper stating that he was positive there were no limit records. MC did not shoot the victim. C. Moda's lawyer filed motions right away after both witnesses were forthright and stated that Moda was not the shooter. Barker contended that the recantation raises a number of constitutional issues, pointing out that Mr. Jordan repeatedly informed law enforcement and prosecution that his 2003 recorded statement to the JPSO officers was false, that the person he saw commit the shooting was unquestionably not Corey Miller, and that he did not want to lie under oath about Corey's involvement. The attorney's filing stated that the state had never once disclosed this information to Mr. Miller or Mr. Miller's lawyers. After more than 15 years of legal proceedings, a judge decided that the new evidence was insufficient for a retrial since it was dubious when it was brought before the court approximately a year later. The state trial court found contradictions and falsities in both Donnell's and Kenner's affidavits, which led the court to conclude that the affidavits were not credible and unreliable to serve as proof. Judge Vance addressed Arnell and Kenneth Jordan's recantations, stating that their appealing statements were suspect and not reliable. A. Snorts. Man appears on television, writes a sworn statement, and claims he was coerced into lying under oath. "The person I saw shoot the gun was not Corey Miller, and the court says it is not enough," he states unequivocally. If Ken were to testify and deny that Miller was the shooter, he might be charged with a felony. Prosecutors would only need to demonstrate that he made contradictory claims while testifying under a Louisiana perjury statute, not which specific instances he lied. Consider this. A witness who claims he was forced to lie could spend up to 40 years in prison simply for lying. The penalty for perjury in a murder prosecution is 5 to 40 years in prison. In essence, the system sets up a trap. If you testify against someone, you run the danger of spending decades in prison if you subsequently claim the testimony was untrue. This detains people from ever coming forward and revealing the truth. Some of the most prominent people in the entertainment and legal industries have been involved in the C. Murder case. Kim Kardashian West, who started privately advocating for the release of New Orleans rapper C. Murder in 2020 after he was wrongfully convicted of murder and given a life sentence, has recently become more outspoken. Kim Kardashian stated, "Corey Miller deserves a day in court to test the veracity of the reckoned statements and prove that he did not shoot Steve Thomas," in an August 2023 social media thread outlining the case's facts and pleading for justice. Ronald Haley Jr. and renowned civil rights lawyer Ben Crump, who previously defended the families of George Floyd, Breonna Taylor, and Ahmaud Arbery, have also joined his defense team. The fact that he took on C. Murder's case speaks volumes about the kind of injustice he feels took place here. In 2009, the same murderer was sentenced to life in prison without the possibility of parole and was sent to Louisiana State Penitentiary in Angola, but he has consistently maintained his innocence despite the support of celebrities like Kim Kardashian and Monica, the R&B singer and former girlfriend of Murda, who has been one of the most persistent advocates for his release over the years. But what about his own family? Music. According to a tweet from my mixtape on March 4th, 2026, Master P said that his brother might have been home years ago if he had listened to him and accepted an 8-year deal. The relationship between my Murda and his brother Master P has been problematic. According to a quote from Master P, "You have to listen to the people who love you sometimes." This reveals a side of the tale that is seldom discussed. An 8-year sentence and a plea deal were reportedly on the table at one point. Say Murda refused to accept it. He insisted on his innocence and decided to contest it in court. Depending on your point of view, this choice was either morally right or disastrous. Music. Refusing a settlement makes sense if you think he's innocent. Why admit guilt to something you didn't do? However, from Master P's point of view, his brother might have served 8 years and returned home. Instead, he is currently serving 24 years in prison. The pragmatic move and the principal move were two different things. After the Bet Doki series No Limit Chronicles aired, Percy became more aware of the circumstances surrounding the murder of Master P's incarcerated brother C, which led him to organize for his brother's release. On August 17, 2020, Master uploaded a video to his Instagram account showing Sue's attorney addressing a group of demonstrators, encouraging them to work toward his brother's liberation. Nevertheless, despite all the support, all legal avenues have been closed. Regrettably, Judge Vance's 2023 decision was upheld by 3 circuit judges with the 5th Circuit Court of Appeals. Miller attempted to obtain a certificate of appealability by proving a substantial demonstration of the denial of a constitutional right, but the court determined that his arguments were insufficient to meet the standard. The judges concluded that Miller had not made such a showing, and as a result, his motion for a KIA is denied. The 5th Circuit shut it down, but it didn't end there. On Tuesday, February 3, 2026, the Louisiana Supreme Court declined to consider a second appeal of rapper Corey Miller's 2009 murder conviction. Miller had previously contested his conviction for second-degree murder and his life sentence for killing 16-year-old Steve Thomas in a Harvey nightclub in 2002. The 54-year-old younger brother of rap mogul Percy Master Miller, Corey Miller, has argued that the recantation of testimony by 2 witnesses and allegations regarding DNA evidence during the investigation warrant overturning his conviction or at the very least granting him a new court hearing in the hopes of a retrial. These appeals for post-conviction relief have been denied, and the 7 justices of the Louisiana Supreme Court unanimously voted on Tuesday to say they see no reason to consider them again. Steve Thomas's brother, George Thomas, spoke on the Boss Talk 101 podcast. The victim's family has a viewpoint that should be addressed, but they wouldn't even hear it. "It's a high-profile case," he said during the interview, calling Kardashian's defense of the rapper a slap in the face. "You didn't read all the facts before jumping on a case. You would have said, 'I'm not getting this case,' if you had done the homework. And every year, whether it's BT, something on YouTube, or something new coming up, he's always innocent. He was railroaded. That anguish is real, so my family is unable to grieve in a natural way." For more than 20 years, Steve Thomas's family has heard arguments that the man accused of killing their loved one is innocent. At the age of 16, he went to a nightclub to watch a musician he enjoyed and never returned home. Regardless of your position on the guilt or innocence of C.S. murder, Steve Thomas's family has lost a child, and the fact that witnesses recanted does not make their grief go away. This is where we must directly address the video's title, which claims that C. Murda has finally been exposed after fresh evidence established his innocence. Let's outline what we truly know as of March 2026. As of October 2025, Murda is still incarcerated at the Ella Hunt Correctional Center in Louisiana. On February 3, 2026, the Louisiana Supreme Court declined to consider an appeal of rapper Corey Miller's 2009 murder conviction. The Louisiana Supreme Court reportedly rejected the New Orleans native's most recent attempt to appeal his 2009 murder conviction. Corey Miller, also known as E. Murda, was found guilty of shooting 16-year-old Stephen Thomas at a nightclub in 2002 and is currently serving a life sentence for second-degree murder. As of right now, there may be little to no chance that the rapper will ever return home because there have been no new trials or successful appeals in C. Moda's case. Let's say the murderer has not been freed, he has not been cleared, and no fresh evidence has established his innocence in a court of law. Retroactivity laws have prohibited the non-unanimous jury argument, and the Fifth Circuit rejected his appeal because the two recanted witnesses were not considered credible enough for retrial. Just a few weeks ago, the 7 justices of the Louisiana Supreme Court unanimously declined to hear his case again. The title implies something that has not actually occurred. As of today, March 2026, Corey Miller is still incarcerated and serving a life sentence. Does this imply that the public views the matter as closed? No. Miller's lawyer, Jane Hogan, issued a statement challenging the ruling, saying, "I am saddened that Mr. In addition to having a pending state court petition claiming factual innocence, Mr. Miller has been refused a day in court once more. This decision will be appealed. I am hopeful that he will eventually be given a hearing on a strong claim of innocence." From prison, C. Moda has declared, "I'm still fighting this case. Eventually, they will let me escape." Legal experts estimate that further hearings may take place in 2026 if clemency or a retrial is granted. The governor of Louisiana may step in. Clemency is still an option, and a presidential pardon is theoretically feasible but highly improbable for a state conviction. Federal habeas corpus is still a limited alternative, but it hasn't worked thus far. There are important outstanding problems in this case, one of which is the absence of tangible proof. Another is the compulsion alleged by both witnesses. A third is the juror's admission that she altered her vote under duress. And a fourth is the conviction's 10-2 verdict, which would now be unlawful. The fact that the recantations were made years after the initial testimony, however, is another legitimate reason why the courts have refused relief. In the legal system, recantations are viewed with suspicion because the courts believe witnesses are more likely to be telling the truth when they testify under oath during a trial than when they sign an affidavit outside of court. The judges who examined the affidavit discovered inconsistencies in it, and although the Ramos ruling declared that non-unanimous juries are unconstitutional, the Supreme Court clarified in Edwards v. Vance that this new rule does not apply to individuals whose cases were already final. The C. Moda case is situated at the nexus of a defective legal system and the boundaries of what courts are willing to do about it. In this instance, both witnesses claimed to have lied, and the evidence was weak from the beginning. The individual is still incarcerated in spite of a juror's claim that she was under duress. Miller continues to insist on his innocence, and his brothers and nephew have repeatedly demanded a new trial. Whether future assessments turn up fresh evidence compelling enough to change the verdict will determine the final result. Until then, C. Moda stays in prison, hoping for a shot at justice and freedom that many feel is long overdue. Has a murder of Essie been made public? No. Has fresh proof established his innocence? Many people think it has in the court of public opinion. The answer is still no in a court of law. However, the battle is far from over. Even if it is unlikely, there is still a chance that a court will eventually consent to a second look as long as he kills while still alive and his legal team is submitting motions. None of us can anticipate when that day will arrive. However, the case's facts, the recorded testimony, the non-unanimous jury, the absence of tangible evidence, and the pressure from the jurors will not go away. Neither is the dialogue. That's a whole tale. Please like, subscribe, and share this video with others if you thought it was informative. Let me know what you think by leaving a comment. Is the murderer innocent, or did the system make a mistake? I'll see you at the next.